Good afternoon, everyone. We're so excited to be here this afternoon to present this webinar, which we have entitled Electronic Monitoring of Migrants, Alternative to Detention or Just Another Form of Punitive Custody. This panel is sponsored by the ABA Commission on Immigration and the section of Civil Rights and Social Justice. And it's one of a whole series of webinars that are sort of rapid response webinars. We are always planning additional programming on a variety of issues. So we really do encourage you to visit americanbar.org/CRSJ to see additional programs that are available. During the program today, we encourage you to ask questions of the panelists through the Q&A function, not the chat function. If you're not seeing that, you may need to just jiggle your screen to make sure that it's live and look for that Q&A section. And we will do our best to address questions. We hope to have time for a Q&A period at the end of the presentations, and so we'll try to get to as many questions as possible, time permitting. We will be sharing a recording of this program with everyone who is registered so that you can then share it widely with your networks and have that for your use. So let me introduce our panel. I will be moderating the panel today. I'm Denise Gilman. I co-direct the Immigration Clinic at the University of Texas School of Law, and I am a member of the Advisory Commission to the Commission on Immigration of the ABA, and I'm also a liaison to the ABA section on civil rights and social justice. And with us, we have an amazing multidisciplinary panel. We have Dr. Dora Schreiro, who is special advisor to the ABA Commission on Immigration and is a longtime corrections expert and advisor. And then we have Dr. Austin Coker, who is a research assistant professor at Syracuse University, working with the Transactional Records Access Clearinghouse, an amazing resource. We also have Dr. Scott Allen, who is a physician, medical director at the Access Clinic at the University of California, Riverside School of Medicine. And finally, Dr. Carolina Sanchez-Boy, who is a Carlsberg Fellow at Aarhus University, an affiliate with the City University of New York as well, and who has been doing really extensive research on electronic monitoring of migrants, and will be presenting some of that work today. As you can see, it's an incredibly diverse and multidisciplinary panel. And so I do just want to, as we begin, raise a couple of legal issues given the forum with the American Bar Association that overlay the conversation today and that might be worth thinking about. First is whether the dramatic increase of monitoring of migrants, electronic monitoring of migrants as a so-called alternative to detention, whether that's even constitutional or legal. It seems appropriate to consider that this is a deprivation of liberty, and there's certainly case law that defines as much. And it's a deprivation of liberty taking place in connection with civil proceedings that should therefore be non-punitive and only applicable where there are special limited justifications for that need to ensure appearance at hearings or possibly appearance for deportation. And generally, such deprivations of liberty in civil proceedings must be very strongly justified as necessary. And so a question is raised as to whether or not this type of electronic monitoring is necessary, at least on the scale that we're seeing it being implemented, as we will discuss today. In the same vein, there are procedural due process constitutional questions about whether there is an adequate system of checks and balances for challenging the imposition of monitoring where it is in place, whether there is sufficient consideration of individualized circumstances in a proceeding that is fair and appropriate and that applies due process. There are other legal implications about the lawfulness as well. Privacy law and other areas of law come into play also. And then a final sort of legal question that's more sort of nuts and bolts is just the question of what are the legal advocacy strategies that lawyers might actually deploy to address the effects of electronic monitoring on clients that they are seeing, whether that's to remove or challenge monitoring devices in individual cases, to deal with the privacy matters, or otherwise to address the impacts of this increased deployment of electronic monitoring. With that, we'll get started with the discussion. Thank you so much for that. Dr. Schwiro, do you want to begin? You're muted. Dora, you're muted still, I think.
Okay, how's that? Good afternoon, everyone. I'm going to start with a super quick summary of INS's contributions. It's an oldie but a goodie, and then go on to an overview of corrections best practices for assessing and addressing risk, and then end with several observations about ICE's current alternatives to detention practices, ADT, as I will call it, with a couple of suggestions as next steps. So INS undertook a 3-year pilot. It's called the Appearance Assistance Program, AAP. It began in 1997 and ended in 2000. And its job was to assess the impact of supervision on people in several categories who were in removal proceedings. And those groups of people were asylum seekers, criminal aliens, those with convictions, and documented workers who were apprehended at work sites. What they attempted to do, INS, is to evaluate 2 levels of supervision, and those are both intensive and regular. The intensive was reserved for those who would otherwise have been detained, so this was a true alternative to detention, as well as a regular level. And that was intended for individuals who were ORR'd and volunteered to participate. And that was to see if a program such as this could create some additional value. There was also on the part of INS, when they created this program, they wanted to have a better understanding as to the occasions when participants might be at risk of failure. So it was not just looking at different types of people categories, but the circumstances under which they would do better or get a little shaky. And they also recognized that along the way, that this was not a clear or a straight path, that there were things that could trigger. It might be a family incident, something at work, could be anything going on with their proceeding that might cause them to lag and require some additional support. The results were really quite striking and so promising. By and large, individuals in all 3 categories, both regular and intensive, did exceptionally well. More than 9 out of every 10 completed in its entirety, and only a grand total of 11 with some intervention when they did get shaky actually had to be returned to custody. If it only worked so well today. So that's a little bit about what INS did. It was supposed to go to a phase 2 enlarged pilot program, and that never came to be. But I think the lessons learned are so important that I wanted to resurrect them today, and now move on to talk a little bit about the underlying theories. In part, what INS did was to replicate or take some of the best practices that pretrial services in the federal government was doing on the criminal justice side. Now, I'm always going to be the first to point out that there are appreciable differences between individuals in the civil and the criminal justice systems, but there are still some important lessons to be learned. And so here are a couple of them. Risk assessment, when it's done correctly, is a blend of both static and dynamic factors. The static can't be changed. That's how old you are. It's what your criminal record is and what your institutional conduct has been. The dynamic factors are really more important. Those have to do with whether or not you're a substance abuser at that point in time, you've had sexual misconduct in your background, and if you're currently unemployed or frequently unemployed. But the risk assessment is really key to the level of service and the kind of services that you require. The way in which one comes to a risk assessment is by conducting a viable risk assessment or custody classification process. And that's a combination of developing information that is both validated, but then also calibrated for the specific population, and to recognize that factors change over time, as do we with dynamic characteristics. And so that recalibration needs to happen on a pretty regular basis, on average 5 to 7 years. One of the things that's so striking about ICE's approach to risk assessment is that its instrument, regardless of the score that you receive, that you're at low, medium, or high risk, their risk assessment now always recommends detention. And that's one of the bad practices about which those of us who are involved in this always do. What's the point of assessing what risks someone you can subject to if everyone that is going to land in immigration detention? Now, of course, we know that's not feasible because there are only X number of beds, but it's also why however many beds there are typically being filled. Some of what we learned on the criminal justice side is in the literature of what works. And first and foremost is that there is this thing called the risk principle. And this is something anybody who knows me for 2 minutes knows that I talk about all the time. And that is that that even if you are high risk, that is not the same thing as bad risk. Because once you know what those dynamic factors are, you can account for them just as INS did so elegantly over 20 years ago now. And so things such as how you think, who your associates are, what your current coping and problem solving skills are has everything to do with how well you're going to do. There's also the needs principle, which is to recognize what those underlying factors are and to consider what can be done to mitigate those issues as well. And of course, there's the supervision and support principle, which again, INS had really nailed. One of the things that's striking when then you toggle over and look at ICE's data today, and so off their website, their most recent information is from January of this year. They currently are offering 4 different kinds of supervision strategies. And again, contrary to the risk principle, where the majority of people in ICE's custody are actually assessed to be low risk, although they'll be detained whenever there is that bid to detain them. When you look at the technology set, they offer GPS, SmartLink, Voice ID, and then no technology. Just 12% are assigned to no supervision strategy whatsoever. And so that really suggests that this is neither an especially effective nor an efficient approach on the part of ICE. One of the things that's also striking is that the vast majority, 82%, which is in excess of 290,000 people as of January, are on the maximum level of supervision, meaning they have a combination of all the electronic strategies plus personal check-ins, and so back to what we learned from the criminal justice side of things, and that INS showed is also true with the detained population. If in general we mess with them too much, they're going to mess up. One of the things that I find so striking about the detainee population, that is those in the custody of ICE, that specific maxim that I just mentioned is far less likely to apply with them. They, as a group, even those who are criminal aliens, someone who might have some criminal conviction in their background, they are so motivated to prevail in their seeking of relief that they overcome all these obstacles that all too often cause people to fail when they're in criminal justice supervision. You know, supervise me more than I need and I'm not going to do well. Don't supervise me as much as I need, I'm not going to do well. It's different with ICE. Everybody gets, well, 82% get stuff whether or not they need it. And whether or not they need it, whether or not we mess with them, they succeed. They succeed the vast majority of the time. One of the other things that's especially striking about how we focus and don't focus on people, how we do and don't use our resources, is when you look at the amount of time that people spend in the custody, whether it's in the community or in the facility, really varies remarkably and not in a good way. Again, using ICE's most current data, folks who are in detention, in part because of the expedited detained docket, which was to address when people languished in the facilities, is on average 49 days. But for folks, single adults who are on any of these supervision strategies, are on supervision an average of 270 days. So, you know, it might appear to be less restrictive, but for the length of time, it is extremely restrictive. Likewise, that the numbers are upside down as well. ICE is still somewhat recovering from COVID when there were significant numbers of releases or reductions in introductions or admissions to detention. ICE is currently detaining about 19,500 individuals, and they're holding them for an average of just 49 days. So a lot shorter time, smaller number of people. If we could just invert this whole thing, that would be good. That leads me to a couple suggestions that I have. Just one other piece of data to look at, which is also a suggestion. On ICE's website, they have a listing that shows all the institutions and some of the data. And one of the things that always strikes me is that there are a large number of people detained in each of these facilities when you go down facility by facility on the list, and a fair number of them have no criminal history whatsoever. And yet they're also identified as being subject to mandatory detention. It just really suggests to me that there's a whole lot of data that needs to get cleaned up and kept scrubbed on an ongoing basis. The other thing that I've seen from the various reports that I've done over the years is that there are appreciable practices between field offices along the border and field offices on the interior. And so even though you're dealing with people who've been assessed low, medium, or high using the same instrument, that the field offices along the border are far more likely to release people on supervision or no supervision, but with no untoward differences in the outcomes, which again suggests that ICE, if they just looked at what it was doing, could be doing more. It would also be really helpful if ICE was to continue those referral procedures that were put in place as a result of COVID-19. There weren't any appreciable differences in failures or risk to the community. And so every reason that we should continue to keep low and reduce again further what the detained population is. It would also be, I think, especially helpful to consider a redefinition, whether it's operational or a matter of law, as to what in the custody of means. Clearly, in this under the supervision in ETD is a form of being in custody, and if it was counted as such, again, I believe we could reduce the number who are in detention. Next to last is ICE really needs to redo its risk assessment instrument. It needs to get rid of that only recommendation, which is detain regardless of the custody level, and it needs to recalibrate its instruments so that it far more accurately identifies everybody who is indeed low risk. And last, it would be really helpful if ICE had some experts in the topics that we're describing today. The individuals at ICE do an exceptional job. Their expertise is enforcement, but when it comes to alternatives or what civil detention looks like, I think they could use a hand. So I'll stop right there and thank you all.
Dr. Shapiro, if I might, just before we go on, when you say that despite the more intrusive supervision that's taking place, that sometimes if it's over involvement can be normally detrimental, but yet with migrants they are often succeeding. What do we mean? Do we mean they're succeeding in that they're appearing at their hearings, in their immigration cases?
Yeah, under ordinary circumstances, as I said, if you mess with me too much, I'm gonna push back. But again, ICE, the individuals in ICE's custody, which I'm as already defining as being on alternatives, they are so motivated to prevail. The stakes are so high if they are returned to their country of origin, that they go to extraordinary lengths to meet the requirements, no matter how excessive and unnecessary those requirements are.
And when you describe the sort of imbalance of there are far more people for longer time in the various alternatives detention, so-called programs, electronic monitoring related programs, as compared to those in detention. You talked about sort of the imbalance of that. Can you say just a few more words about that? I mean, are you envisioning that a more ideal model might be one that looks at, well, 20,000 people in some form of physical custody currently, that should be maybe more or less the overall numbers of those in any form of custody, including electronic monitoring, rather than treating monitoring as sort of
it's really two things that who really needs to be detained always requires review. But also, what is the scope and scale of the people who are under community supervision? So in both instances, how many and how long are really the key questions. And of course, if you're in the community, but you're under the surveillance of the government for that many more times, 49 versus 270 days, that in and of itself is another form of a punitive set of conditions.
And then finally, and I'm sorry, I just can't resist because I know you have such amazing expertise, and then we'll continue on. But you've described pilot programs and other empirical research that suggests that this level of monitoring is not necessary, or at least that those are the indicators. Can you help us to understand why it is happening to such a great degree then?
I think it's for the same reason that again, ICE are experts in the area of enforcement. And so, I guess the theory is that, if when that person is identified for removal, they want to know exactly where they are and they want to be able to move them at the earliest opportunity. But thank you for this, because I didn't mention this about the AAP program, that one of the remarkable things is when individuals were ordered to self-report, they did. And one of the other things that INS did, if the ruling was that they were automatic to be immediately removed, then from court, they went back to custody. They didn't keep those folks out on the street because they knew it'd be short. And they also knew that there was some risk at that point in time.
And just to follow up a bit, all of that makes great sense. In terms of financial incentives, which way do they run on this? I can't resist raising the question of who is receiving money for the electronic monitoring programs.
Yeah, well,
from who?
Whether it's when it comes to detention, I'll just expand on that for a sec. So whether you're a public or a private provider, you're making money, a lot of money to do this work on behalf of ICE. When it comes to alternatives, it is primarily the private sector through some continual prodding on the part of Congress. There are these efforts at case management, and case management to a limited extent has come to include the public sector. But by and large, this is a private operation.
Thank you. Sorry for all of the questions. I'm sure others will pick up on some of the same themes, but I just wanted to put them out there. Dr. Coker, do you want to join in?
Sure, thank you. I'm going to share my screen here. I've got a couple of slides for everyone. Can someone on the panel just give me a thumbs up that that's coming through? Okay, excellent. Thanks. So my name is Austin Coker. I'm a researcher at Syracuse University at TRAC, and we use Freedom of Information Act requests to study the federal government. Immigration happens to be one of our big areas. I'm an immigration geographer myself and study the deportation system, broadly speaking. As a geographer, part of my interest in alternatives to detention and electronic monitoring is the fact that that electronic monitoring really represents a really significant shift in the spatiality of state power and immigration enforcement and control in the United States, but also in Europe and England and other places. So it's a geographic question as well as a legal question. But for the purposes of today, especially, it's a data question. How many people are being tracked and what do we know about them? Before I get into the data, I just want to add just a little bit of context to make sure that we're on the same page. ICE's Alternatives to Detention program is more formally known as ISAP. It's now on its 4th contract of ISAP. The agency has been using the program since, I believe, 2003, 2004, when they rolled it out. It is a partnership of sorts between a private company called BI Inc., which has been around since the early 80s, late 70s. They initially tracked livestock, used RFID technology to track the feeding schedules of livestock, and then bought some of the patents for the electronic monitoring technology that was developed in the United States in the 70s and moved into electronic monitoring as the US government began to rely more heavily on private contractors for both private immigrant detention as well as sort of the expansion of electronic monitoring throughout the criminal system, as well as later on the immigration system. Wanted to just emphasize that BI does not just have a contract with ICE in the civil context, but has many, many contracts throughout the country with parts of the criminal legal system as well. It's sort of in terms of number of contracts, certainly ICE's contract is probably its largest, but has many, really part of the carceral system. So we want to look a little bit at some of the data here that we get. And I preface that just because the data that we have comes from both data that ICE posts publicly, but also share some of the data and reporting that we've done at TRAC to understand with more granularity and precision what's happening with the program. So because the program is managed from a private company, this data is sort of both from BI and from the government, and there's some issues with that we'll address at the end. So we've already noted that there's been a massive expansion, but let's quantify that a little bit. Effectively, at the end of the Trump administration, less than 100,000 migrants were being monitored at any given point in time by the program, about 85,000 when President Biden took office. Pretty quickly in the first 4 or 5 months, the program was expanded pretty dramatically, and more recently crossed 350,000. So, a third of a million people monitored at any given point in time. This data comes from ICE's public data releases that they issue about once every 14 days. This is not the generosity of the agency being transparent to the public. This is a requirement that Congress has mandated that the agency comply with, and we'll address some of those issues in a moment, but that's the data source for what we're looking at now. But just looking at totals doesn't really tell us who all is on the program. So breaking that out by technology over time shows us, adds some granularity to the picture. So to Dr. Shirio's point, most of the growth that has taken place on ICE's electronic monitoring program has taken place because the agency has adopted and expanded its use of a smartphone app called SmartLink. Now, traditionally, electronic monitoring has been thought of and written about in terms of GPS ankle monitors, those little black boxes that are strapped to people's ankles. And certainly that was the case for a long time and still is for a significant number of people. But there's been a technological shift towards using a smartphone app to do this. Telephonic reporting still remains part of ICE's suite of monitoring technologies, which is effectively more of a landline legacy technology, which has stuck around. But SmartLink is really where the growth has been. A note on the alternatives to detention terminology and why the workshop is called electronic monitoring, and why I tend to use the phrase electronic monitoring specifically is that there's a lot of reasons why this isn't a real alternative to detention, as the phrase originally suggests. And I won't go into all of those reasons, but the plainest and simplest one comes directly from ICE's own description of the program on its website and in testimony they've given to Congress, which is they have clearly said that alternatives to detention is not an alternative to detention. Alternative to detention is an alternative to unsupervised release. It's a distinction that's very important because alternatives to detention might give you the impression that this is a way for people who are detained to get out, or might represent some broader shift in policy or disposition towards the use of detention. This is not the case. ICE, in fact, has increased its request from Congress to budget in terms of detention beds. But we can see a pretty dramatic increase. We're going to come back at the end to these red bars at the bottom that show these unknown numbers. We'll come back to that at the end, but so hang on for that. There's some gaps in the data, is what I'm saying. So telephonic reporting has generally been on the decline over the past couple of years and is now down around 15,000. There appeared to be an increase in July, but we can't be really confident that this represents reality. General decline in telephonic reporting. Also a more significant decline in the use of GPS ankle monitors from around 35,000 2 years ago to almost 5,000 now. And part of this has been an explicit policy by the Biden administration. I suppose you could say responding to some critiques of the technology as, invasive. We saw with the video, it's very demanding. It represents its own significant burdens, and to Professor Gilman's point, deprivation of liberty. But that technology has been on the decline. We have also seen recently in the data the increase of people. This is people who are on no technology. And I should just note too that even if someone's not in the ATD program, there are still reporting requirements for people who are in removal proceedings or who already have a deportation order. So I'm not totally clear on what the distinction is from ICE's perspective between this group and people who still have to report but aren't on ATD. But I just put those numbers there to show you that they've been pretty significant recently. Where the action has been is SmartLink. And so this shows you the overall growth in SmartLink over the Biden administration, reaching as high as almost 300,000. So, more than 3.5 times the number of people that were on alternatives to detention 2 years ago are now just on SmartLink. And I won't go into the concerns in my initial portion, but perhaps we can get into it in the Q&A. But there are some concerns that even though SmartLink might represent at the subjective individual level of the migrant, certainly better than being in detention, perhaps, and better than being on a GPS ankle monitor, I think there are still some issues with privacy. There are concerns that we'll hear about in terms of sort of the psychological effects of being on any type of persistent monitoring technology, and some broader social and political questions around what does it mean that the U.S. government would be monitoring a third of a million people on any app. Who's responsible for that data? Are there adequate protections in place? What does it mean for communities of color? That, let's say, parts of New York City where there's a large number of people who are in removal proceedings or are being monitored by ICE's technology. What does it mean for a neighborhood to have 1 in 20, 1 in 10 people monitored at any given point in time? So there are some geographic concentrations of this technology that we shouldn't think that this is just an aggregate. This is going to concentrate in communities of color, and there might be aggregate emergent effects of that we need to take into account. My final graph for this part has to do with SmartLink itself. It's only been in the most recent data release that we've seen a total decline in the number of people on SmartLink. Again, I'm a little skeptical of this data because ICE has made some pretty egregious data errors recently, so I put a big asterisk here. But I do want to note that last spring, for instance, the ICE was adding 1,000 people a day to SmartLink. That's aggregate. That doesn't even include people who are disenrolled. So there's been periods where, just a really massive number of people have been added to SmartLink and therefore to electronic monitoring over a very short period of time. This data that's made public by ICE, though, is not very granular. And so we at TRAC have been interested in getting more detailed data about the composition of people on ATD. And one of the most important findings that we have published already, and 2 reports we published a couple months ago, is really showing that actually, even though there's been, at most 350,000 people on ATD at a given point in time, that's aggregate. That's sort of gross for any point in time. That doesn't include people that are disenrolled. And when we got data through the FOIA process to look at the total number of people, what we actually see is that about 500,000 people have been impacted by the program between August 2020 and June 2022, come through the program. And so here you see on the top bars, you see the total people added, and then beneath it, you see the people who left that month. So what you actually see is obviously in the aggregate, you have less than that, but it shows you also the turnover. So the number of people impacted in any given month isn't just the growth from data release to data release. It also is important to take into account those who are disenrolled, and as many people are. Using that similar data, we've also been able to look at nationality. This is not data that ICE releases publicly typically, and we think it's really important for the public and for the for folks in policy and research to be able to understand who's on the program. So certainly these graphs around nationality, and let's say in this case, the growth of Nicaraguans in the electronic monitoring program, represents what's happening at the border as well, because that's where a lot of people are being enrolled in the program, most people. So it certainly reflects border issues, but nonetheless, we think it's important to look at the nationality on there too. I won't go into great detail with these. I sort of want to move to the end. The last demographic piece. We've also, there's concerns around the relationship between the securitization of migration enforcement and control and gender. And so one of the things that we saw when we were able to look at gender is that when you look at the population on GPS ankle monitors, this is at the end of 2021 anyway, 3/4 of them were male, only 1/4 were female. Whereas when you look at telephonic reporting, which I think could probably be considered the least invasive, potentially, of the technologies, much more female than male, according to the data that we got from ICE. So, we think it's important to be able to understand the compositions of people on there and be able to ask research questions about, about how people's experience on the program is shaped by nationality and gender and other factors. I want to close with the data quality concerns that we have around ICE's public release and private release of data. I showed you at the very beginning these sort of unknown errors that exist in the data. Basically, in the fall, here's what happened. We were tracking the data and reported, because ICE had published several weeks of data in a row that showed significant increase in the use of GPS ankle monitors, that it went from around 10,000 all the way up to 60,000. Really massive growth in GPS ankle monitor use. It was surprising to us, but those are the data that the ICE released. And then in December, the agency reached out to say, oh, we messed up. We've been releasing egregiously wrong data for several months. Please correct the data on your website, TRAC's website. Well, they did publish new data that month. And eventually they went back and fixed the year-end report, which was wrong from the end of the fiscal year. But they have yet to correct any of the data that they released in that time period. And this represents a concern for us, because it's not as if this were new. This was new. This was certainly an egregious error, and ICE effectively misled the public about the people on this program. But we had already noted this months ago. We have consistently found small and large errors in ICE's data that they release to the public. And just again, just as a reminder, this is data that Congress has required the agency to release, and they continue to mess it up and make pretty significant mistakes. Sometimes they release data that's 2 years old and it sits on their website, until they get around to fixing it again. Or they'll release data that's lacking a significant amount of data. And so the data is effectively quite riddled with errors, and we really have to spend a fair amount of time making sure that the data that they post publicly before we process it and use it actually appears to reflect some kind of reality, which it doesn't always. So we just raised this, and I raised this as a significant concern, because it's not enough that Congress mandate that the agency release this data. The agency needs to do it right. It needs to release correct data. So we'd like to work with the agency. Our preference is always to work with the agency. The agency has been relatively unresponsive to addressing our concerns. We hope that they will, be more responsive going forward, because, at the end of the day, we just think that the public deserves, accurate, up-to-date information about electronic monitoring, given its massive expansion. So I'll end there. Thank you very much, and I look forward to questions at the end.
Wonderful. Thank you so much. Dr. Allen.
Thank you, Denise. It's both an honor and a pleasure to be a part of this distinguished panel today on a very important topic. I do want to begin with a disclosure. I am a subject matter expert in detention health with the Department of Homeland Security, Office of Civil Rights and Civil Liberties. That's important for everyone to understand. I'm not here speaking on behalf of the department. I'm here in my own individual academic capacity. So thank you for indulging that disclosure. My comments are actually going to have to be brief, and it's for the simple reason that I was asked to review what is known about the health effects of alternatives to detention, and it's a very thin literature. Understanding why it is important. First, there's the broader issue that if I can really call back to 35,000 feet, we often in public policy deploy new technologies and go charging forward with them without fully understanding their effects. This is further complicated by technologies and approaches that are used in detention settings. These are areas where research, and Austin's work notwithstanding, research particularly around health is always spare. And the reasons for it are, there are three reasons I think that these health effects are often not well studied. The first is the simple fact that doing studies in detention settings or in vulnerable populations who are under detention or surveillance requires extra hurdles with institutional review boards, those offices that protect human subjects, so that there are barriers to studying these populations. Having said that, studies can be safely and appropriately done and respect the rights of people in vulnerable situations. I myself have done research in jail and prison settings, for example. The second issue that plagues, that results in a lack of data in terms of health effects in these populations is among people who do health research. Health and detention is often a neglected area, that a lot of the people who have the skills and the resources to look at these problems aren't aware of what happens beyond the walls and to populations who live out of sight and out of mind. And then finally, another barrier to studying the health effects of these approaches is gaining cooperation and trust of detaining authorities. You can't study the adverse effects without getting cooperation of detaining authorities. And if you're postulating that there might be harmful effects, you're often going to meet with resistance. So I think those are really important issues to frame what little data we have, because they can be addressed, and it's incumbent upon us to try to get better understandings on the effects of these technologies. And like in all areas, technology is moving forward so quickly, we haven't really had time to adapt and adjust and understand the effects. So having said that, the limited data that we have to look at is largely restricted to the health effects of the now less frequently used ankle GPS monitoring technology. And there are really two key studies. I think we've shared them with the group or will in our links. The first one comes from 2011. It's National Institute of Justice report out of Florida in a criminal justice context that looked at 5,000 individuals and found that 89% reported significant adverse impacts on their relationships, particularly intimate relationships. And then also vast majority reporting a sense of shame and public humiliation. In 2021, the Cardoso School of Law, their Immigration Justice Clinic, conducted a survey of 147 individuals. And they reported, when we watched the film at the beginning, the young man said something along the lines of, it affects your thinking and it affects your body. And this is the findings of that review as well. As regards to physical effects of the ankle monitors, 74% of the people who responded reported pain and cramps, 57% reported heat discomfort, 55% numbness, 45% various types of inflammation, 38% reported scarring, 27% chafing, cuts, and bleeding, and 22% reported electric shocks. I was also able to find in reviewing the literature something I hadn't anticipated, but a report from surgeons who had to do emergency surgery on a subject who was wearing an ankle monitor. If any of you have ever had surgery done in an elective manner, you're often asked to remove your jewelry, including your wedding band. That's because of the electrocautery that goes on in the OR, and there's a grounding risk to having jewelry on. There's a real grounding risk to having an electronic battery-loaded device strapped to your ankle. So this created complications and delays in access to emergency surgery in the case report. So that's worth noting as well. The same study looking at mental health effects found really high levels of problems reported. 80% of the subjects reported anxiety. Again, in the video, the young man spoke of difficulty sleeping. 73% reported sleep deprivation. 71% reported depression. 61% reported social isolation. And I think others have talked about this, that there's sort of a self-isolation that goes on related to the stigma. 12% reported suicidal ideation. And while that might strike everyone as a low number, I can tell you in the health field, no, that's a blinking light. Suicidal ideation is a very worrisome symptom to report. and 12%, seeing it in 12% would be a real threat. So both physical effects and mental health effects. A couple things I want to add in terms of the context of those effects. One has already been mentioned by Austin, that there are racial disparities among who the technology is deployed with, and related in terms of who the technology is being used with. The individuals who are in immigration detention or surveillance system have high rates of prior trauma in their home countries. And we know in mental health that trauma and the effects of trauma is cumulative. So you're talking about a vulnerable population that is more primed to have adverse effects, and including not only just physical traumas or mental traumas, but the very active surveillance. And in their home countries, there may have been issues related to surveillance by state actors as well. So there's a priming effect and a cumulative effect that has to be taken into consideration. And I think while we don't have good data yet on technologies like SmartLink, the mental health effects of monitoring a largely traumatized population need to be anticipated and considered. And then there's one more issue just from the mental health literature relating to immigration detention in general. And that is the indefinite nature. And others have talked about this, that one of the things the technology has allowed is maybe a lower cost threshold across, I'm not just talking about money, but in terms of ease of use and so forth, with the perhaps inadvertent effect of longer periods of using this technology. So people are spending longer periods under surveillance. And the indefinite nature of that can have really adverse effects on people. It's even worse than knowing that you have a long duration, but a definite end date versus maybe it's short, but you don't know when it's going to end. So, in conclusion, I think the main thing to say is we don't really have enough data. And if we're going to use these technologies as broadly and widely as we do, it does need to be studied more. And there are people who can do this safely and respect the dignity and human rights of the subjects. And that also, it's important to understand that although perhaps these could represent some improvements to traditional detention within facilities, when we ask the question, which is worse, I often think that's the wrong framing. The important take-home message is to understand that these technologies also have risks of harms. So speaking as a physician and not a lawyer, and a physician who's worked in detention settings for over 40 years, I think that it's incumbent upon us to ask, should we be subjecting people to these deprivations and conditions that carry high risks of harm and that diminish their dignity when we haven't thoroughly understood what those harms could be, and when we haven't thoroughly exploited less restrictive alternatives.
Thank you so much, Dr. Allen. We had a very specific question, just to be clear, the statistics about the 12% suicidal ideation and high level 70% and above depression, those were specifically studies relating to ankle monitors. Is that correct?
That's correct. And if there are studies on technologies like SmartLink, and I don't think that there are, I looked far and wide and didn't find them. And by the way, if anyone on the call has information or knowledge about such studies, please share it with the group. But I'm not surprised that there isn't good data yet. It's a relatively new technology, and as Austin has shown us on his great data slides, that's rapidly been expanded. So obviously calling out to be studied, particularly for the psychological effects. I think we'd anticipate that physical effects would be minimal, but the psychological effects should be studied.
Thank you so much. And thanks to all who are posting resources. I've also posted a link to some resources that we've already put up on the webpage, but we'll continue to add other mentions that are taking place. So that's really helpful. Thank you very, very much. All right, so we're gonna pass it along to Dr. Sanchez-Boe. And
So as I said before, the video was shot in 2019. And last time I spoke with Lorena, she still had the SmartLink app on her phone and still found it very disruptive and very stressful. So I have the people, the two persons that you saw in the videos wanted me to thank you for attending this panel and for taking part in it. For them, it's really important that these issues are being raised, and that's also why they accepted to be filmed, even though they wanted to stay anonymous for obvious reasons. But they wanted to tell their stories because they wanted other people to, they didn't want other people to experience the same thing that they had experienced. I don't have many minutes left, but I wanted to say that one of the official reasons behind electronic monitoring is to make people comply with their court dates. It's one of the different justifications that are often given. There's nothing easier than to cut off your ankle monitor and throw it out, or to throw away your phone and get a new one. So actually the reason why people are complying with electronic monitoring is because they want to get their day in court. And that's one of the ambivalences that I think we need to stress always. So we saw that Lorena missed her court date, even though she was being monitored constantly, and even though she complied with everything that she was asked to do. And I think that's really important. And it's also important to know that because there's a for-profit motive, and because the electronic monitoring is being managed by private for-profit companies who have also been very central in the expansion of prisons, of detention centers, and the alternative to their own ways of incarcerating and detaining persons. People who are monitored are mostly in contact with officers who are not really able to give them information about their, in this case, of their asylum case, or in other cases, their legalization cases. I thought that was really important. What I mean, thank you so much, Dr. Allen. I think you've raised so many questions that I've seen during the interviews that I've carried out with persons who had been monitored and who had gained asylum or legalization, or persons who are still under monitoring. There is self-isolation because of the stigma. And I think it's also important to raise that and this is a little bit newer, since the Mississippi raids, the workplace raids that took place in Mississippi in 2019. There's also self-isolation because people are afraid of endangering others. So there's actually a self-isolation taking place because people want to be protective of their communities, of their co-workers, of their neighbors, of their families. And you also raised the question of the and Dr. Frey raised it too, of the indefinite nature of monitoring, and so, as I said, Lorena has been detained through a smartphone for much longer than the average, and I think it's really important to stress that that the not knowing when you will be taken off a monitor, whether it's the ankle monitor, or whether it's the smartphone, or whether it's being detained and not knowing when you will be able to get out of this form of supervision or confinement, and also not knowing how it's going to end, because in the criminal justice system, most people have a set end date when they're being monitored. We know that that people can stay in the criminal system for a very long time, despite the end of their monitoring. But what's really important with immigrants, with whether asylum seekers or whether undocumented migrants or people who have been residents for decades and who are in deportation proceedings, is that they don't know how it's going to end. So they don't know if they're going to get asylum or legalization tomorrow, in a month, or in a year, or in 5 years. And they don't know whether they will have the monitor taken off because they will be legalized, because they will get asylum, or because they will be deported to their home countries. And that's a very significant difference between criminal monitoring and what we see in the immigration system. But I think I'll end here, and I look forward to the Q&A. Thank you so much.
No, thank you for those thoughts. Very, very helpful. So we've had some lively chatter already in the Q&A and in the chat. So please do keep posting questions in the Q&A. But one theme that has come up repeatedly is just the impact that monitoring can have on access to housing and employment, beyond the pure direct mental health and physical impacts that may be there. And so I wondered if anybody wanted to address that particular issue. Wonderful. Carolina, why don't you start?
I give the example of one from Pakistan who came to Austin, Texas with 3 children. She and her husband, or the family and her husband had been separated, and after a few months, they found out that he was in detention in a northern state. So she tried to find employment. It was really difficult for her, as a lot of other people that I've met, that the stigmatizing factor that Dr. Allen spoke about. But she eventually found, this is Austin, so she found a job in a food truck, and her boss said that she could work there because nobody could see her feet, like nobody could see her ankle monitor. But one day her ankle monitor was not charged enough, so it said battery low, battery low. You heard in the video how disruptive that sound is and how loud it is. And so she got fired. She got fired because her boss said, we can't have somebody looking after our clients who has an ankle monitor. But I think I have a lot of examples, but I think this one is one of, it's one of many. Oh, and I think after the Mississippi race too, there has also been an impact on workplaces, of course.
Does anybody else want to address that issue? And then there have been a number of questions about some of the technicalities of the data. So if anybody wants to address those, whether the studies on GPS monitors have looked at different types of GPS monitors, whether that matters. But I'd also just like to take up the broader question of why the data is important. Dr. Coker, you mentioned that there's missing data and that the public should have knowledge. There should be sort of transparency and accountability. Dr. Shapiro, you mentioned the importance of data-informed decision-making, policy-making, both writ large in terms of what technologies are used and in what way, and then individually in individual cases, making sure that the best decisions are being made about what is needed. So maybe the two of you could speak a bit more to sort of what types of data are still needed and what the relevance of that data is. And yes, Dr. Allen, you also mentioned the need to have more data. So if any of you would like to speak about that more, that might be helpful.
Yeah, thank you. I'll kick it off. Something that's been of great concern to me for quite a while, and it carries across all administrations, is there's a tendency for hyperbole. I just all too often, when talking about people who are in ISIS custody, they're described as the worst of the worst. And there's generalization about criminal history. You'll note that when I made my remarks, I paused and said, I'm talking about convictions. ICE has become so expansive in its definition of a criminal alien. It exceeds statute to include people who were charged but never pled or proven, and then even that it would be anyone who could have been charged, by doing or not doing a particular thing, and it goes well beyond the law. It's not helpful when you're trying to make evidence-based decisions. So having clear definitions and rigorously staying to those definitions, and that they conform with statute or case law are all critical. But this is ultimately when you're trying to ascertain what would put the public at risk, and then what do we as policymakers do so as to mitigate that risk, to look to the science to the extent that there is, and there's plenty out there, as I indicated, on both sides of the fence, meaning on the immigration side, as was initiated by INS, and unfortunately is not so rigorously carried over since ICE's inception, but on the criminal justice side as well. And also to appreciate when you can borrow from one discipline to the other, and where there are limitations when you do that. So they're all critical to making the best decisions and getting the best outcomes.
Dr. Cooker, did you want to add anything about the data?
Sure. I mean, it's somewhat redundant. I mean, the reality is we can't understand a program that we don't have information about. And so, data is essential for public understanding, for policymaking, for responding. To everyone's point, there are all kinds of consequences to the electronic monitoring program. And I think it's relevant for social service organizations, immigration attorneys, and other organizations to be able to prepare, to understand what the scale is, let's say, of people in their state or their city or their community that might be impacted by electronic monitoring, and understand where the need is. We see this with our data, with tracks data, and all kinds of other areas, asylum cases. People use our data to say, oh, how many people in our state are seeking asylum? That might impact, how you think about strategic planning. And so this, is similar to all of that. I would add an additional concern here is that, to be frank, ICE has not been tremendously forthcoming with many of its programs. It hasn't done a sufficient privacy impact assessment. EPIC, the Electronic Privacy Center, has done some important work on this, showing really the lack of its evaluation of its own program. And this, like detention and like many other of its programs, let's not forget its participation in family separation just a few short years ago, where part of the problem wasn't just the policy, but the problem was the agency's refusal to cooperate and really work with, until it was forced to, people who are trying to reunite families. And so I think what it's partly it partly reflects a broader disposition at the agency that, I think that it ought not have to be accountable and transparent to the American people. And I realize that that's not necessarily everyone in the agency's perspective. I know there are many people who would like to work better with, public partners and civil society, but the agency still has a long way to go. And I think we can see it with both the sloppiness with which it releases public data, its lack of commitment to basically doing things accurately and doing things correctly. Part of that is a lack of commitment, I think, to just being accurate. But part of it also reflects, I think, potentially anyway, and I'm not the first to say this, certainly more of a culture of just sort of refusal. And we'd love to see that change, because whatever people may think of alternatives to detention and electronic monitoring, it simply is an essential part of a democracy that agencies are transparent and accountable.
Two concrete questions that have come up is regarding what type of data is gathered by the monitoring. I don't know if you have additional information about that, and then whether contracts with the relevant entities, BI and so forth, have been made available at all.
Certainly, many of those contracts under federal FOIA law have some exemptions in them for proprietary information, and because we're dealing with an outside private company in this case, a lot of that information is allowed to be withheld. I haven't seen any unredacted contracts, so we have seen some old ones that suggest some, help us to understand the program a little bit, but I haven't seen any of the current ISAP 4 ones. And as far as data goes, the data for electronic monitoring appears to be well integrated with ICE's more general data system. So the ability for ICE to release redacted, data that doesn't include personally identifying information, but it would include, at a minimum, we've seen data on, like I showed in the graphs, nationality, gender, when they enrolled, when they disenrolled. And by virtue of that, there's other, one could see, oh, was this person in detention and then released on electronic monitoring? Were they enrolled on electronic monitoring from the get-go? So these kinds of data are possible. There are various levels of technological work that's required to do that. So it's not all, as simple as just, exporting a spreadsheet. But there's a lot that's possible there. Yeah.
I think part of the question went to, and Carolina may have some information on this as well, is to what data is ICE gathering as a result of the monitoring? In other words, what types of geographic location data and other data on either those who are monitored or even those who are in their vicinity as well on the privacy?
Dr. Sanchez, do you want to take that one?
I think that one thing that we know is that we don't really know yet, but we have like little indications once in a while, because one issue is the official data that ICE is releasing that Dr. Koga is really like has enlightened us on. The other thing is that we often think of surveillance as something which is happening immediately right now, but there are these extremely huge data sets, huge archives that are being produced, sometimes leaked or shared. We saw or sold. We saw recently that a think tank, a conservative think tank, used data that had been extracted from SmartLink. We don't know where it came from, but it probably came from either ICE or BI Group, which is the private contractor that produces the data and gathers it. And the thing is that these archives are will be exploitable maybe indefinitely too, because they can live on. Maybe in 10 years, it will be possible to look at where somebody was at a certain moment. We know that also as citizens that somebody could be able to look at our smartphones and see that we were, well, we're not in the same room right now, but that we were in a sharing a room at some point and possibly conspiring. So we know that we're all producing a lot of data, but here these are data that are not being produced voluntarily. So it's all very opaque still, but it's certainly something that we should try and look into and try and find alliances so that we can so that we can know more about what kind of data is being produced and sold and archived in a way.
Austin, did you have one more thing you wanted to add?
Sure. So the interesting thing about SmartLink is that the app allows for high volume, high sort of quality data interaction. So there's facial matching technology that's involved. It's not exactly facial recognition, not to confuse it, but there's document sharing. There's the ability to text and communicate back and forth, which, with deportation officers and also with BI staff, it appears. And I think one of the more concerning issues has to do with geolocation. Currently, ICE has been very clear and adamant that they are not collecting persistent geolocation information, that they're just recording geolocation at the time that a person does their virtual check-in. I have no reason to think that that's not what's happening right now. But to be clear, the app is capable of doing persistent geolocation monitoring. And it's not clear because of the lack of clarity around some of these issues, and because there hasn't really been a full privacy impact assessment and some of the other issues I raised. One question going forward to Dr. Allen's point about anticipating issues is, if it were to be turned on, either in an individual scenario or as sort of an aggregate, operational shift, what does the agency believe its obligations are to inform either its users or the public that this change would take place? And it's not clear that there's anything built in, let's say, to the user agreement that one signs on to when they download the app. It's not clear that they would have to re-accept new terms and conditions. The terms and conditions is sort of built into the app, and whether you're a person on, a post-conviction or pre-conviction release and you're using BI's app in the criminal legal system context, or whether you're in the immigration context, it's not clear. It's sort of a catch-all. So seems to allow for maximum authorization. So it does represent some concerns going forward. Not that I believe the agency's not been transparent about this, but again, it's sort of I would say trust but verify, but I wouldn't even trust. Skeptical but verify.
Thank you, thank you. And I also want to touch on a theme that was raised in the second video that was shown about the fact that despite complying with the technology, with the reporting system, there still was not information provided about the hearing date. And to link that back to the question I raised at the very beginning about sort of procedural due process in all of this, and where the lawyers advocating for migrants might come in. Just as a quick straight up clarification, the entire monitoring system, whether it's through ankle monitors or just in-person reporting requirements or other reporting requirements, is quite disconnected from the immigration court hearing system. Those of us who practice in immigration court regularly know that, but it may not be completely evident to others. And so while the monitoring is intended or is justified as needed to ensure appearances in court, it actually does very little other than making sure that we know where people are to ensure that people appear for court, in the sense of providing any information about court dates or other information about the legal process or about how to find an attorney. And that's just inherent in the program. It's a completely different thing to appear for your court date and to report to ICE. And in fact, the fact that you have to report to ICE often confuses people so that they think that they have done their compliance with their proceeding, when actually they have an entirely separate court date that is not raised for them in reporting. So I just want to make that abundantly clear. And so all of that raises again the question of what can we do for clients who are under these monitoring regimes, where they still have every interest in working through their immigration court cases, and yet are suffering sort of a number of impacts, whether that's an impact on housing, access to employment, still not obtaining information about their proceedings. And I unfortunately don't have any silver bullets at all, but I will mention that in the materials that we keep talking about, there are a few limited guides that have been put together that are pretty geographically specific about how you might go about seeking to de-escalate, is what the terminology is usually used, the monitoring by seeking to have a requirement removed. And unfortunately, it does seem to be that it's very specific to particular regions and to particular contacts. But I guess it's in part, this is to put in a plug for attorneys to think about what might be done, to think creatively, to do the investigation into what's happening at the local level, to try to think of advocacy strategies to put their clients in a better position. And then it's also a call, I am making a call to all of us to be thinking about larger legal strategies on this. And there is some case law, there has been some litigation, but pretty limited around the right to have individualized review of custody determinations that are made, putting people into the various supervision programs. So thinking as a group, as a legal community about that would be very important as well. So we probably better leave it on that note for now. And leave it with an incredible thank you to all of the panelists who've been with us today for this webinar. You all are doing such critical work. It's so important, helping to fill in the gaps in the expertise on so many levels. And we really thank you for taking your time out of your schedule to share your experiences. And also just to remind everybody who's listening today and watching that the section of Civil Rights and Social Justice will continue to provide these sorts of free webinars and resources for legal professionals and advocates around the country. And we really hope that it's helpful in your work. Please consider, if you're not already a member of the ABA and involved in the ABA, consider joining. And you can find that information at americanbar.org/CRSJ. And thank you, everybody, for a really wonderful discussion.